She's 9 months pregnant. Set to give birth to her in about 12 days or so. She's in a good place. And
All right, so this is the third time she's probably learned her lesson from stealing. Why do you keep stealing? Parties announced for the record. State.
Megan Galloway.
Defense.
Roberto Ambrosino.
And are you Ms. Robinson?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Ms. Robinson, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property, $2,500, 2 or more previous convictions?
Yes, ma'am.
It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Robinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not.
All right. For clarification, is there an application for deferred or no?
No, there's not. I may have just grabbed the wrong form and I circled community supervision instead.
All right. So with regards to the plea bargain agreement,
I did not. Did I not check it off that there's no?
thank you. So according to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's no application for deferred adjudication and the state is recommending community supervision and there's a $2,000 fine. Did you understand that to be the plea?
Yes, ma'am.
And defense, is that the plea?
Yes, Your Honor.
And state, is that the plea?
It is, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, and no contact with Don and Benz. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, it's been some time since the incident. Since something happened recently. She is in a better place now in her life. She's employed. She's 9 months pregnant. She's set to give birth to her in about 12 days or so. She's in a good place. And
All right, so this is the third time she's probably learned her lesson from stealing. Why do you keep stealing?
Before I wasn't in a better position than what I am now, and that was something that I picked up in a bad habit.
What, a bad habit of stealing?
Yes.
How do you develop a habit of stealing?
It was just something that I chose to do. It was a choice. And
But I'm just trying to figure out, how do you develop the habit for stealing?
it just happened, and
Well, I mean,
something
did you
that
all
was-
plan? Did you all say, hey, let's go to Don and Ben's and take tequila?
Yep.
no, it wasn't anything like that. Like I said, I was in a bad predicament and I was using that to like pay rent or do any, just making any
No, I
type
don't
of-
know. Because, and let me just explain to you why I don't realize that.
Understand.
Because people will spend money on their wants, but not on their needs.
Right.
And what I'm reading in here, everybody in the vehicle was dressed to the nines. So obviously, there was money for clothes, there was money for hair, there was money for nails, there was money for gold, there was money for gold grills, but then people are saying they're stealing for other things that I don't understand.
Right.
And then going to Dunn and Ben's, the officer said that the car smelled of marijuana, and you all just went to Dunn and Ben's. Oh, I needed rent. Who's out here buying stolen tequila?
I don't smoke, so I don't know.
No, I said, who's out here buying stolen tequila? Did you take orders where you just say, hey, anybody want tequila? Because it's saying that you took
6 bottles.
yes, of tequila, 2 coconut bottles, reposado,
Yes.
and
Regular.
yeah. So see, she remembers. So why? So that you all could drink and have a good time. How old are you?
I'm 28. I was 17 at the time, and that was just how I was making my money. There's no excuse for it. I'm not making no excuse for it. And like I said, that's something that I'm not doing anymore.
And the people you were with, this Latasia Bateman, who is that?
Just a friend of mine, or was a friend of mine.
All right, and who is this? I guess their mom named them T.I. Era Barber.
Yes,
Who is that?
just another friend.
What does T.I. stand for? Is that their name,
I
T.I.?
think it's T-Era.
Oh, the officer then put an apostrophe. Okay.
Right.
All right, court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. If you were drug tested today, what would the results be?
I'm gonna be clean.
Okay. There's to be regular UAs, regular reporting by Zoom or in person. Are you employed?
Yes, ma'am.
What do you do?
I work for home health.
Doing what?
Pretty much like assisting and aiding. I'm with.
What does that mean, assisting and aiding?
I pretty much help feed, change clothes.
A credential or are you like a CNA?
I'm not a CNA. I'm just a caregiver.
No, do you go into people's homes and do this? I don't allow people on probation in this
This is
court.
an actual. It's like a nursing home. It's not just like a home. It's a like it's a nursing home, like an actual.
So she doesn't go on.
So it doesn't go into people's houses. It's a actual facility.
All right, I'm not going to allow you to continue to work there unless I receive a letter from your employer stating that they know what you're charged with and you can still work there. And then the people that you're taking care of, they either need to sign something or their relatives need to know that you're working there.
100%.
All right, then their relatives need to know that you're working there. That's, Ms. Abrams, that's what I'm ordering. So proof of employment within 30 days. No employment with minors.
She is on maternity leave right now, so I don't know if you might be able to extend 30 days out a little bit longer than that.
Oh, just speak to probation about that. I consider myself to be reasonable.
Just thought I'd put that on the record.
I appreciate it.
It's going to be, 30 days from 2 weeks and then.
Oh, trust me, probation will say she's on maternity leave. And I'll say, okay. There's to be no employment as a home health care provider in someone's residence. And also, she's not to be a home health care provider at a facility. Without a letter from the employer stating that they are aware of her criminal history and she's allowed to work there, and the family members or whoever she's caring for is aware of her criminal history and they have no objection to their working there. Field visits 1 time per month for 3 months. 200 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, 100 of those hours will be waived. And then I'm going to order the theft course. Once that's complete, the remaining hours will be waived. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Oh, and I'm sorry, just one other thing. There's to be no contact with Lastasia, Lastasia, Bateman, Batmam, and Tierra, Tierra, Barber, Barber. All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. If you need anything, let probation know. If you feel as though they're not addressing it, you can always come back to the court.
Thank you.
All right, you're welcome.
Yeah.
Just remain in court probation. We'll go over conditions. All right, the court is calling 2025 CR 007562B and 2025 CR 009816 State versus Kelly Aguero. Could I have parties announced?
Jason Garrett for the state, Your Honor. Amber Nader for the state as well.
It's Scott for the defense.
All right. So off the record for a moment. So they don't have the W to signify waiver numbers anymore?
The clerk informed me at the last sitting we did this, but they don't do that.
Okay.
Unfortunately.
All right. Just so I can know where we are. All right. We're back on the record. And cause number ending in 16, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these? I'm sorry, state.
Yes, Your
Just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, sir. I think
All right, to the clerk, so I don't have a copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Could I
copy.
see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 16 with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 62B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, no objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 16, you're charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. Here, our counsel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, If for any reason your deferred adjudication were revoked, the court can find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 62B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, if you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Aguirre, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes, sir.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense,
Yes, Your Honor.
state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement, in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution, parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguero, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right, then, and
There's a minor done that was done, I guess, after here from the paperwork. As far as the no contact, where the agreement is now, because this was, I guess, continued from the last setting for CPS record purposes for us to do, other than and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury case. And so
why did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they agreed.
All right. So they're asking then for no harmful or injurious contact with Layla Aguero. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry, 7526B, how do you plead to count 2?
No contest.
And cause number 2025 CR 009816, how do you plead?
No contest.
State any evidence.
Regarding both cases, Your Honor, state not proven that evidence cases is one, those have things.
No objection.
In each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow.
For the other one, or some of this one, we got reset for a couple weeks.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney
That one's
Tomorrow.
tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But, I guess it wasn't possible when we reset it.
Okay.
But, if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in so the court can see what's going on.
I think they keep, the state can
Have
make
those,
a profit, Judge, if they completed everything.
here's the thing, in some situations, I don't like proffers because people need to be on the record for what they have done.
Oh,
So,
see if we can get the CPS.
all right, and they can appear by Zoom.
okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing.
Oh.
And sentencing will happen on that day, all right?
All right.
Once
Thank
you
you.
sign the reset form, you're excused.
Thank you.
You're welcome. All right, the court is calling 2022 CR 5387, State versus Candace Cox. Can I have parties announced?
Melissa Albin for the state.
Scott Hill for the defendant, Ms. Cox.
Defense. Can you ask them to move down there, the attorney? Thank you. All right, we're back on the record. And you are Ms. Cox?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Candace Leah Cox who was placed on deferred adjudication in 2022 CR 5387 for the offense of possession of a controlled substance? All right, we're going to go off the record. All right. With regards to the motion to enter adjudication of guilt and revoke community supervision, any requests from the state?
Yes, Your Honor, we'd like to make an oral amendment to the allegations as far as the offense that she was placed on probation for. It should read possession of a controlled substance, penalty group 1, less than 1 gram.
Any objection?
No objection.
All right, Ms. Cox, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Candace Lee Cox.
All right, Ms. Cox, the state is requesting an amendment to the motion to enter adjudication of guilt and revoke community supervision. They're asking that it be amended to include the words possession of a controlled substance, penalty group 1, less than 1 gram. That's a substantive change. Do you have any objection to continuing with that change?
No.
All right, and are you waiving notice?
Yes.
All right. State, you may proceed.
Your Honor, we'll proceed on violation of condition number 41, the last condition. On or about the 21st day of February 2023 in Bexar County, Texas, the defendant Candace Leah Cox then and there failed to comply with the rules and regulations of the felony drug court, and that the probationer absconded and illegally removed their GPS monitor. This is in violation of condition number 41.
How do you plead to that, true or not true?
We'll waive the rest, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not an agreement, Your Honor. We're recommending revocation and 1 year in the state jail, and I think Mr. Hill is asking for something different.
Yes.
Judge, I can put her on as a witness as well as her mother, but just to give you the Cliff Notes version, right now, she understands. Her mom, she had a serious drug issue back when she took this plea, back in, I think, early 2023.
Mhm.
Her mother, who is Miss Juanita Garcia in the wheelchair, to protect her daughter, who was 6 at the time, moved her and her husband sitting right behind her,
Mhm.
moved down to Corpus Christi and took her daughter.
Mhm.
She could not be without her daughter. So she did something she shouldn't have done, and she understands that.
When you say she could not be without her daughter, are you talking about your client's daughter?
Yes, Judge.
Okay.
So irrationally, she admits that she made a mistake. She just moved down there. And her daughter was 6 at the time. She didn't want to lose contact with her. Now, her mother did that to protect her 6-year-old because she had a drug issue at that time. When she moved down there, her fiance went with her. Not too long after that, her fiance passed away in her arms, had a heart attack, and that has completely just changed her. She's not doing drugs anymore, Judge. In a state of irony, Judge, her disobeying and breaking the conditions of her probation has actually propelled her. Not that it has anything to do with that, but she found herself, Judge. She got help. She's been clean for over a year. She's solely responsible for taking care of her parents and her 9-year-old daughter. So everything is going great in Corpus. Now I'm hoping that the court will consider, because she's doing so good right now, and you can hear from her mother in a second if they need to extend her probation and maybe transfer it down there. She's happy to do whatever the court wants her to do, but sending her, she knows she deserves to probably do a little time for what she did. But I think that in the long run, it's going to hurt her mom and her dad and her daughter even more, to the point where the state will probably take custody of the daughter because the grandparents aren't physically able to take care of her. So those are the issues I want to. And if you need to hear from some witnesses, happy to put them on.
All right, well, what I can tell you, here's my issue. Number one, I don't know if you've been cleaned or not because you didn't report. I don't understand why you would cut off your GPS and leave Bexar County when I know that felony drug court would have addressed those issues with you. So what have you done on probation other than cut off your GPS monitor and leave to go live with your mom when your mom removed your daughter from this situation because you have a drug addiction? So what have you done?
I've just been taking care of them.
No. What have you done on probation?
I've made a visit,
Judge, I think
visited with the probation officer.
she had one visit. It happened like right after she was put on deferred, Judge. I think she had one visit and then she left.
Okay. That's a problem. I mean, because felony drug court is there to help you. And what you just pled to is you removed your GPS monitor and you absconded. And you were on probation. And what you did was you took up a space that somebody else could have had because felony drug court, they're always at capacity because it's a very good program and it's to help people with drug addictions. So basically what you did was you cut off your monitor after your parents had left. And the reason why your parents left and took your daughter with them is because you were not an appropriate person to be around a 6-year-old. So what did you do? With your drug addiction, you cut off your GPS and then you left. I'm not going to continue you. I'm going to grant the motion and I'm going to find you guilty. I'm going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's to be no unsupervised contact with minors, and I'm going to recommend the therapeutic community. I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. CR 7826A, State of Texas versus John Wayne Perez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael DeLeon for Mr. Pettis.
And are you Mr. Perez? All right, everyone, we're on the record, so I'm going to ask that you please whisper. If you cannot whisper, then do not talk while we're on the record. All right, did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision? With your attorney, did you understand it? All right, you're going to have to make sure you speak up.
Yes, Your Honor.
All right. Are you the same John Ray Perez who was placed on deferred adjudication in 2022 CR 7826A for the offense of burglary of a building with intent to commit theft on January 10th, 2023 for a term of 2 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 1, on or about the 8th day of November 2023 in Bexar County, Texas. The defendant, John Ray Perez, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. And Your Honor, we waived the other violations alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
We're asking that you deny the motion and continue the defendant on community supervision. We would like to alter and amend the conditions for SATIF. That's going to run concurrent with the new number 1, concurrent with County Court 2 case 721097.
All right. And with regards to the county court cause number, is that case still open?
It is, Your Honor, because it's enhanceable. I would like the defendant's going to go down and plead directly after this sentencing to that cause.
All right. And who's the attorney on that case that's in misdemeanor court?
Feel like it's me now. So
You're just coming forward solving problems.
I'll take care of it, Judge.
All right. And Mr. Perez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
John Ray Perez,
All right, so what's your drug issue?
marijuana.
All right, we're doing more than SATA for marijuana, are we not?
That's the only drug I just.
I'm sorry, Judge, I didn't hear you.
All right, Mr. Perez said the only problem he has is marijuana and nothing else.
Your Honor, we don't have any. We don't have any drug tests to confirm that there
Yes.
was a violation to his outpatient program.
Have you done anything on probation other than
I went to-
not report, pick up a new case and not doing your drug testing?
I went to my classes,
What classes?
the drug classes.
Obviously, they're not working, right?
Right.
So you're just telling me you'd rather go to 2 years to the state jail facility and then come out and use your marijuana?
No, Your Honor.
Then why are you using marijuana? Because I know people think marijuana is not a big deal, but I tell you what, in Texas, it is. And you can't smoke marijuana or use marijuana in brownies or cookies or whatever while you're on probation. You can't even drink alcohol while you're on probation in Texas. So would you like, if you want, I will grant this motion and I will send you to the state jail facility. You will be done. And if you choose to smoke marijuana, that's on you. If you get caught smoking marijuana, you're going to get arrested. That's on you. So if you want treatment, I will give you treatment. But if this is just, I'm doing my best right now to stay out of custody as quickly as possible, but you're still going to use, then now's your time to make the call because you know yourself better than your attorney does. And is there a family member here for you?
No, ma'am.
All right. So you know yourself better than I do and the attorneys do. So if you want, I will deny the motion of alternate amending conditions and send you to SATA. Or I will revoke you and sentence you to 180 days.
Your Honor, if I may,
Yes.
Mr. Pettis and I had a conversation. I think he wants to avoid having a felony conviction on his record. He doesn't have any other felony convictions before, so that was the reason why when probation recommended SATF, we're like, okay, we'll do it.
Okay.
I had the same reaction when I heard marijuana as well. I'm like, but unless that's different, Mr. Pettis, unless you want to do 180 days and just have a conviction on your record and do 106 months in state jail facility.
180 days?
Yeah,
It's day for day.
day for day, but it's a conviction on your record.
And let me just tell you what's going to end up happening. When I do that, if that's what you want, when you are released, you're going to immediately go back to doing what you've previously been doing. And one or two things going to happen. Either you're going to pick up another evading case or something else is going to happen. And you're going to be right back in somebody's felony court or misdemeanor court or whatever. And your problems will still be there because when you stop running, your problem is still there.
No, I'd rather take the help.
Okay. And is there something you wish to say?
Oh, yes, Your Honor. I believe after speaking with probation, his probation will need to be extended 6 months to accommodate the SATF judge.
All right, it will be extended. However, if you complete everything, then of course you can ask for early termination. You understand?
Yes, sir.
All right, so this is what I'm gonna do. I'm gonna extend you for 2 years. Alternate amending conditions to do a referral to felony drug court. And if felony drug court doesn't accept him, then it will be SATA.
That'd be great.
Felony drug court will be able to probably interview. Next week is a short week, but they may be able to get to you next week. And you need to be honest with them about your issues.
Yes, sir.
All right. Probation, we'll do felony drug court first.
Yes, Judge, and then decided he's not accepted.
Yes. And that's to be while in custody.
Yes.
All right. Is there anything else you need from the court to be successful?
No, Your Honor.
All right. We can go off the record. How old are you?
I'm 31.
All right. Do you want to be the 31-year-old at the prison where somebody asks you why you're here and you say it's for marijuana? All right. Do better.
Thank you.
All right. Good luck to you.
Hey, Judge.
Pettis was already on deferred adjudication for burglary when prosecutors accused him of violating probation by committing a new offense, evading arrest. After pleading true to the violation, he stood before the court, facing the possibility of revocation and a felony conviction.
All right. Court is calling 2023 CR 9472, State versus Ricardo Ramirez Jr. Can I have parties announced?
Luis Martinez on behalf of Mr. Ramirez.
All right. The defendant has previously entered a plea of true on the motion to revoke, and we're just here for the court to sentence.
Correct, Judge.
All right. Yes.
Judge, so Mr. Ramirez, the court had sent him to adult drug court with the idea that he was perfectly willing to do that. When he gets there, he just doesn't qualify because his needs aren't great enough for that. We wanted to address the SATF issue with the court, didn't have a chance to do that before the MTR was issued.
Mhm.
But we're here, we've conferred, I've conferred with probation, I've conferred with the state. What we think is appropriate, given his needs and given the TAP evaluation and what drug court found. We're hoping that supportive outpatient and a year on scram, there's a new scram bracelet, would be sufficient for the board.
All right.
Judge, Steve Jarvis was here, on Thursday when we were kind of looking over the case. And the recommendation that's listed on the court summary, he did not agree with. We combed through on the court summary and on the TAP evaluation, we combed through the case, and based on the violations that were presented, we just felt like status would not be the best option, and it would just be overkill basically. So we did come up with a plan for supportive outpatient treatment, and then getting him on the track watch if the court.
Yeah, but that's correct, Your Honor. We all kind of conferred together, and that was what we came up with.
Okay. Anything you want to say? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Ricardo Ramirez.
All right, what do you want to say?
Yes, ma'am. I was issued the initial MTR in January and I've been compliant ever since. No major violations. I've been working hard on complying with everything that the court has issued. Working the game from boy. And I am working. I have a good job. Status would require me to leave that job, which I've been at for almost 12 years.
Mhm.
It's very important.
So here's my question for you. So obviously, someone believes you need some type of treatment. And what I can tell you, when you get to the point where it's a DWI third, obviously you're a person who has a problem controlling alcohol intake. So the only issue we're here for today is whether or not I'm going to send you to inpatient treatment or whether or not I am going to follow the agreement that's been reached. So what you need to focus on with me is not that it's going to cost you your job or any of that. You need to focus with me on what have you been doing to maintain your sobriety. So tell me about that.
Yes, ma'am. I've been going to AA regularly. I completed the initial counseling that was recommended in the original probation. I made sure I finished those classes and obliged by by your judgments.
And how often have you been doing AA meetings?
A few times a week.
All right. So what do you mean by a few times a week?
2 to 3 times a week.
Okay. And you can continue. What else have you been doing?
I thought you were on scram for a while.
I was on scram, so the initial MTR back in January had me at 30 days on scram. I was on it for about 60 days, no violations. Still on the ambulance, still on the breathalyzer unit. Just to show you that I am committed to sobriety. So I've had no major violations since January, so almost 9.5 months. I am dedicated. I am willing to show you that I am dedicated.
All right. So this is what you need to realize. And this is what I tell a lot of people. So if you are unsuccessful on this probation, you're looking at potentially 6 years in the prison. And you know, if you end up going to prison, you're probably going to lose your employment. You understand? Probation. So, do you think he needs the intensive outpatient treatment? Or do you think continuing with sober support meetings isn't?
Judge, I would say the supportive outpatient treatment, in addition to, at a minimum, in addition to his sober support meeting.
All right. So how often do you want him to do sober support meetings?
Twice a week.
All right. So number one, you're going to have to do NA or AA meetings 2 times per week at a minimum. Do you understand? Now, if you need more than that to maintain your sobriety, of course you can do more.
Yes.
But at a minimum, 2 times per week. Do you understand?
Yes.
And then they want supportive outpatient treatment, so I'm going to order that. And then with regards to the alcohol monitoring device, what are you requesting?
He's currently on the portable device, a portable handheld device. Another way that we can track alcohol monitoring is either increase the amount of times that he flows into that device or put him on that track watch, Judge.
Which is the least expensive?
Well,
Because it's the track watch. How much is that?
that one's the one that's either $5 or $10 a day.
So track watch, that's $5 to $10 per day.
Mhm.
So you're looking at about maybe $150 a month, or perhaps $300 a month. Or you can remain on the other device that you have, and you're going to have to blow in it more than what you're blowing into the machine for testing.
I'm okay with getting the device and doing it more often.
All right. How often do you?
How often does he currently?
3 times a day.
3 times a day?
Yes.
Every day, right? There's no,
Every day.
yeah. 5?
And that's-
Feasible?
I think that's feasible. If
All right. Then it'll be testing 5 times per day. All right. Is there anything else?
Nope.
All right. Thank you for addressing appropriately for court. They'll go over conditions with you. Make sure you follow them. Okay.
Yes, ma'am.
All right. Good luck to you. Thank you. Are y'all ready to proceed?
It's right.
All right. Court is calling 2020 CR 10020 State versus Adriana Ayala. Can I have parties announced?
Rick Pena for the state of Texas.
Judith Wemmert for the defendant.
And are you Adriana Ayala?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney?
The document, I did.
Did you understand it?
I did.
Are you the same Adriana Ayala who was placed on community supervision in 2020 CR 10020 for the offense of assault family second offense on October 11, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Thank you, Your Honor. Violation condition number 41. On or about the 30th day of May.
Excuse me, I don't have a violation of 41. Is that a supplemental?
No.
Thank you, Ms. Abrams. Oh, I have the incorrect one.
Oh,
All right, you may proceed.
yes, Your Honor. Violation condition number 41. On or about the 30th day of May, 2024 in Bexar County, Texas, the defendant, Adriana Ayala, did then and there fail to comply with the rules and regulations of the Esperanza Court, in that the defendant absconded from the women's sober homes in violation of condition number 41.
How do you fix that, true or not true?
State will waive the other violation. Your Honor.
Any objections to the
No, ma'am.
waivers? Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion, and sentence you up to 2 years in the prison?
Actually, so she's supposed to be against me. She's supposed to be for me. Why did you just give him some paperwork to be against me? If he didn't want the paperwork, it shouldn't have been filled out. Because it's not complete, but his records are not complete.
I just pointed something out to him on his paperwork.
Because his paperwork was in your hand, it's not in his hand.
No,
I didn't. That's why he's reading it now. Because he didn't have it earlier.
All right, so this is what the state is accusing you of. They're accusing you of not following the requirements of Esperanza Court. Do you understand that? All right, you just pled true to that allegation, which is number 41. Do you understand that? And do you understand that the state is not proceeding on any other violations in the motion to revoke? They're only proceeding on violation of 41. Do you understand?
Yes, I am.
All right, so do you still wish to plead true to violation of condition number 41?
I do, yes, ma'am.
All right, by pleading true to violation of condition number 41, the court could sentence you up to 2 years in the prison. Do you understand?
Yes, ma'am, I do.
All right, the court is going to find violation of condition number 41 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's community supervision and sentence the defendant to 2 years TDC.
That is the agreement, Judge.
All right, the court will sentence you, the court will grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. Did she pay the $100 to the approved Family Violence Center? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Correct.
All right, you can lower your hand, state your name for the record.
Adriana Ayala.
Yes, did you pay the $100 to the approved Family Violence Center?
I don't remember. I did pay my $1,000,
For the court?
Yes, ma'am. But I don't know, what else was included, so my dollars, but he said I didn't know, Mr. Patrick said and Thorpe said I didn't know any fines. So I'm thinking that might have been included,
Okay, let me ask.
but I'm not.
If I may, Your Honor, the court summary reflects that she did pay the $100.
All right, thank you.
Thank you.
All right. So the court then, as previously stated, will give you credit for any time served. There's a affirmative finding of family violence. There's to be no unsupervised contact with minors, and the court will request the therapeutic community. Did you agree to that sentence?
Yes,
Are you waiving your right to appeal?
Yes, I am. You know that.
Yes, there was something you want to say?
I have an idea of how much credit time served I have. Do you have an idea of how much credit time served I have?
I can,
They will be able to tell, no, they'll be able to tell your attorney. The clerk will be able to tell your attorney how much time you actually have in. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
I did.
All right, because you waive your right to appeal, you do not have the court's permission to appeal.
Okay.
Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am, I do.
And I'm sorry, also, as previously ordered in the agreement for probation, there's to be no contact with Cesar Rodriguez.
Okay, thank you.
All right, thank you. Good luck to you.
Thank you.
And Judge, just for the record, I did let Ms. Ayala know that she does have credit for 578 days.
Okay. All right, thank you.
Okay.
May I be excused?
Court is calling 2022 CR 2755, State versus Luttrell Miles. Could I have parties announced for the record?
Lauren Espinoza for the state. Andrea Matos for the defense.
And are you Mr. Luttrell Miles?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Luttrell Miles who was placed on community supervision in 2022 CR 2755 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on July 13, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, state's proceeding on violated condition number 4 of the supplemental MTR, which reads,
All right, just one moment. Does anyone have a copy of the supplemental? I don't have that. All right, thank you. Thank you, Michelle.
You're welcome.
Mr. Miles, did you review the supplemental report?
Yes, ma'am.
All right, state, you may proceed.
violated condition number 4 in Bexar County, Texas, the defendant Latrell Miles did then and there fail to report to the supervision officer as directed for the months of December 2023, January, February, March, April, and May of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
All right.
We would waive all others, Your Honor. And then as for an agreement, we would ask that you grant state's motion to revoke, sentence Mr. Miles to 3 years in TDC, and as well as take into consideration clause number 2025 CR 005391.
I'm sorry, could you repeat the clause number?
2025 CR 005391.
All right. And defense?
Yes, Your Honor, that is our understanding of the agreement. We ask that you follow that recommendation by the state and probation and follow the agreement.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
That's Robbie Shea Miles.
All right, why have you not been successful on probation?
When I was put on, when I was giving me probation, I'm a plumber, doing the UA testing in the morning every day to go to work. I wouldn't be able to go out to go to work and I wouldn't be able to buy it. So I thought.
You didn't even report.
I did 3 times. The lady, she told me that I would have to call, and I'm a plumber. In the morning, we have to go out to work. I can't. I mean, if I would have been able to do it in the afternoon, yes, I could have made waves, but in the morning, I couldn't.
So here's the question. Why do people think when they're on probation, it means that they don't have to report? I don't understand that. Because here's the thing. When you're on probation, you're not like regular people in the sense that you can just go do whatever you want to do. Otherwise, people would place people on probation and say, just don't pick up another case, which they're taking something into consideration. So it appears that you picked up a new case as well.
Yes, I did.
So you had time to pick up a new case, but you didn't have time to report or call your probation officer.
I understand it's a privilege of being on probation, ma'am. I've been in drug court before. I understand.
Mm-hmm. All right. So let me just explain something to you. I am going to grant the motion. I am going to revoke you. But if you continue on the path that you're continuing on, you're either going to end up at somebody's prison for the rest of your natural life, or either somebody's going to come out and identify your body because the last time you use is going to be maybe the last time you use. You understand?
I understand, ma'am.
All right. The court is going to grant the motion, revoke, taking consideration 2025 CR 00539, sentence you to 3 years in the prison. And are you waiving your right to appeal?
Yes, I am.
Okay. And are you asking the court to follow this agreement?
Yes, ma'am.
All right, the court will give you credit for any time served. I'm going to request the therapeutic community. The therapeutic community does not increase the time that you're in custody. So for example, you've received 3 years. I've followed the agreement that you reached. If they are working with you in the therapeutic community and they say, oh, your 3 years is up, but we want to spend more time working with you, they don't get to keep you. The most time you can get is 3 years. That's it. And if you are paroled before 3 years, they don't get to say, we don't want him paroled. We want him to continue working with this class. The therapeutic community is just designed to give you tools. So hopefully you will be able to control your addictions and be sober. You understand?
Yes, ma'am. Thank you.
Okay. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. And I'm sorry, one other thing that I'm going to order is no unsupervised contact with minors. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own. Oh, I'm so sorry. The correct cause number for the case that's being taken in consideration is 2025 CR 005391. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, ma'am.
You're welcome.
Thank you, Joe.
You're welcome. All right. Megan?
Yes, Judge.
So,
I have a chance for the violation report.
yes.
The violation report. I've had a chance to review it, and my review of it appears that the defendant just stopped at places he was not supposed to go, and so let Mr. Martinez offer explanation to them.
All right. So what do you want with regards, what do you want the court to do with regards to the violation report?
For the GPS violations, in my review of them, they're not extremely egregious. I would just ask for a sanction
All right. Are you employed?
Yes, ma'am.
What is your work schedule?
I work Monday through Friday, 3 to 11, and when weekends are posted, I send it to Mr. McCory and he approves it for a set time.
And Judge, this was a miscommunication.
Yeah.
Mr. Garcia's had his car repossessed, so he and his wife were down to one car. He dropped her, he wouldn't got gas in her car, took her to work, and that was it. He had communicated with GPS, thought that issue I thought it was a non-issue. And so that's why we're having, at that point, we get the issue with the GPS thing. He's had some communications back and forth. He's tried to be as open and communicative with people as possible. There are occasionally some hiccups, but we found that if he keeps, number one, if he keeps communicating, and number two, if he's dealing with the same person, Mr. McCory, that we typically don't have these issues. So he's apologetic to the court, but that's the crux of the issue.
It was 2 weekends in a row where he approved my going to work. And I'm literally either on the way or already at work. And first they call me from California and then they call me from pretrial that I'm not approved for set work time. That I have to turn back home. So they've written me up and I was on the verge of losing my job also because of said lack of communication. It's gotten better. And we're communicating on a much better level now. I had to sit down with him the last day I was here. When we were here, and he gave me the UA, whatever, and I passed, and we had a frank conversation.
So is there an issue with communication currently?
No, ma'am. I indicated this morning that I was going to be in court, and if he needed me to go afterwards, because I have to go to the bondsman afterwards, if the court allows.
I mean, it seems like that part is good. His communication with Mr. McCurry is actually pretty good.
Okay.
The problem is sometimes things don't get put in the notes.
Yes.
And if he's going outside of normal hours that have been approved, sometimes it's not in the notes. And so they'll jump on him and that's what was happening here.
Yeah. He went on vacation last week and there was a new guy that I had to communicate with. And I went to work and he says, "Oh, what are you doing? You're not scheduled to work." I said, "My schedule is Monday through Friday, 3 to 11. He said, "Well, he didn't put it in the notes, but let me fix it right now." And I said, out of curiosity, he already had approved the weekend. And did he put that in the notes? And he said, no. And he did it right there and then. So sometimes, I mean, I understand I'm not the only defendant. So sometimes it might miss, but
certainly you're trying to communicate to them as well as you can.
Yes, sir.
All right. And has he already completed the
I'm already set for the in-person assessment for bright lifetime recovery and all that.
he's reading my mind. Get out of my mind. All right. So here's my question, State. Do you all want to do maybe a tracking and specific areas he's not allowed to be in? That's just something to think about. If the issue is he's not being allowed to work, or either do tracking with a curfew.
Yeah, okay, let me just, I'm sorry, that's why you're asking me. And then
Yes.
I'm sorry. Okay, yes, I will look at that.
All right, so guys, just have a seat and see if you all can come to an agreement so maybe we don't have this issue again. And then come up when you're ready to approach.
Yes,
once you sign the reset form, you're excused. And just like that, the judge holds the line and demands real answers before making a final call. She refused to just pass things through without seeing the actual proof and hearing from the caseworker. Justice takes time, but this judge is making sure absolutely nothing slides under the radar.